Thank you. Please be seated. This is the time set for our argument in our civil number 14-697, Mark Rezek versus Farmers. Each side will have 20 minutes in which to argue its position. The appellant may reserve some of that time for rebuttal argument. Counsel, you'll have to keep track of that time for yourself. We've read the briefs and conferenced this case. We're familiar with the facts and issues presented. Would each of you, as you begin your argument, identify yourself and the party you represent? Counsel for appellant, take your seat.
Good morning, Your Honors, and thank you to this court, Mr. Sassman. My name is Don Miles. I'm here with Jennifer Anderson with Jones, Skelton, and Hockley on behalf of Farmers Insurance Company. The fundamental issue we are asking this court to consider is whether or not, in applying the doctrine of judicial estoppel, you must have identity of the parties. Identity of parties is not required in any federal court based upon the decision written by Justice Ginsburg in New Hampshire versus Maine. Every federal court would have applied judicial estoppel given the facts we had in the underlying case.
How do we get around the fact that we're bound by the law issued by the Supreme Court of Arizona?
Justice Portley, that was...
Well, thank you, but that's not the, that wasn't to be, okay?
That's actually how we're going to get around it. We're going to elevate ourselves.
We can hope. In footnote number 1 in the Standage case, the Supreme Court said the following: "We note that although the language of a number of our early decisions set forth the principle of judicial estoppel in terms of applying only to cases involving same parties," it goes on to state, "we do not address this issue and it is not in front of us right now." They had the ability to speak to it. They knew that the prior case, Meekum, said that there was not an identity of the parties and it was not necessary. The Supreme Court punted on it. They didn't address it, and subsequent cases have simply referred to this doctrine by saying same parties, same issues. But that footnote alone is very instructive on what this court can do and is allowed to do under the circumstances. They did not overrule Meekum. They knew it existed. It was a prior case, and they chose not to say anything about it because that particular issue was not before the court. And in none of the cases cited by either party has this issue as to whether or not you need to be specifically the same party in the underlying action, whether it's there or not, other than Meekum. And Meekum said you didn't need it.
Let me raise a question about this. Let's assume for the moment that we can get there based on that footnote, okay, so that we are in a position to conclude that the Supreme Court has not spoken on this issue, and thus we're not bound to follow that. In the Meekum case, however, the transaction between the Meekums and the seller of the property was central to the Meekums dispute then with the city. And so, although the mutuality was not followed, the transaction was so essential to both lawsuits that one could not exist without the other. In this case, it seems to me that Farmers, at least on this record, does not share that centrality of the underlying dispute or the occurrence here. And instead, one could argue that Farmers is attempting to take advantage of the insured's I'll be charitable about this, misstatements on the bankruptcy schedules.
Yes.
So I see a distinction, even if we could say the way is open for us to decide this, I can see a principal distinction between the facts and the circumstances for judicial estoppel in the Meekum case and what is presented here. So how would you help me persuade me otherwise?
Judge Norris, you're focusing on the effect on the parties. Judicial estoppel has nothing to do with the litigants. In the cases that deal with this particular issue, and as the Supreme Court case mentioned, this is about protecting the court system.
Well, that I understand, and I do appreciate that distinction. But I don't think we can separate out principles of law and protecting courts from the circumstances. In the Meekum case, the centrality of that transaction, of the buy-sell and the decision or the agreement to preserve a roadway easement, was so central that what you really then had was the fact that the Meekums were really misrepresenting and using the courts in an inappropriate way. Now, here, because the transaction, at least by my way of thinking, is not central, that although, yes, there's some misrepresentations going on, the bankruptcy court can take care of it, and indeed, we've received all sorts of requests for judicial notice in which it appears that the bankruptcy trustee and others are starting to look into this.
Yeah, and Judge, keep in mind, the bankruptcy trustee wouldn't know a thing, but for the fact that we raised this issue as affirmative defense. Otherwise, the fraud on the court would exist and would continue to exist. If this court doesn't do anything, this will happen again and again. Because what happened as a result of the investigation by farmers, we wind up trying a case where the affirmative defense we relied upon was stripped from us. We were not allowed and were not given the protection of judicial estoppel. And what it will cause, and
You argue at, I'm sorry, Mr. Miles, did you argue at trial, at least bring these facts forward so that the jury could consider this for purposes of credibility or for other purposes in the case?
yes, we did. We tried. In fact, in some respects, we were able to raise it on the misrepresentation claim. I don't want to assert that we didn't, but we didn't have the protection of an instruction that said we were justifiable in doing the investigation necessary to try and prove this affirmative defense. The interesting point is any insurance company in this state who can get to federal court under diversity will have this doctrine available, and given these facts, would have a summary judgment granted in its favor. If you're in state court, however, you're going to be subjected to a trial where that affirmative defense is stripped from you. That's what we have right now in terms of forum shopping. We can't get to federal court because Farmers is an Arizona-based corporation and company. But that's the distinction that's being made now, and what happens is all the other cases we cited in the briefs, the Georgia case, the Sexton case, deal with the exact same facts here. A later filed bankruptcy action where you had, or I'm sorry, insurance claim after a prior bankruptcy action where there wasn't adequate disclosure. And if this is taken away from the companies that must litigate in state court, it's never going to be raised again because we'll be in bad faith for having done it. The other, I know this is the fundamental issue, and I know the court has seen all of these cases. The states of Illinois, Texas, California have all gotten rid of this requirement under the circumstances. And it's an interesting doctrine, judicial estoppel, because it's really to protect the court system. And I know, Judge Norris, you're concerned that maybe this is a windfall to farmers. Boy, they don't have to pay.
I wouldn't say it that way, but admittedly, Farmers is going to be released from its coverage obligation if judicial estoppel applies.
I understand. But it's the protection of the court system, and the court system will not be protected if an insurance company has no right to investigate to determine whether this occurred or not. In fact, you may recall that in the judgment signed by Judge Harrod, we specifically requested that following the trial, if we talked to the trustee or notified the trustee, that could not be further evidence of bad faith. We had a great concern that by going to the trustee and say, hey, you might want to look at this, that could be used as evidence against us for further bad faith. We got that order, and in fact, on the cross appeal, that's an issue they've raised. That very issue that requires the type of disclosure that we got under the circumstances. And we don't know as we stand here right now what the deal is with the trustee. We do know this. We had to go to trial without that affirmative defense in place, regardless. So if this is fixed, and you say, well, gee, in the end, maybe the trustee worked out a deal, maybe some of the creditors are going to get their money. We don't know any of that. I don't know if an EUO was taken, as they were allowed to do. I don't know if there's any deal. Mr. Sassman apparently was just appointed special counsel by the bankruptcy trustee. What's the deal? What are they going to get? Are they going to open it up? And the one case they did cite from Georgia, the usury case, is an instance where the bankrupt estate was still open, and they amended their schedules. This is all over. The schedules were done. They've not been amended. That case is not the same. factually at all. We were forced to go to trial under those circumstances.
Mr. Miles, do you know, or does the record reveal whether the Chapter 7 was a no-asset liquidation?
When you say there were assets.
I recognize there's and I'm not a bankruptcy expert, so forgive me, it's been a while.
Neither am I.
But sometimes when you have a Chapter 7 liquidation, the debtor has so little property that the trustee, there just won't be any liquidation. They just close it out. The debtor has to discharge without any liquidation because it's essentially a no asset. And I was wondering whether the record reflects whether this was, in fact, a no-asset bankruptcy.
The only thing I can tell you, Judge, is he was relieved of about $800,000. I can't answer that question either. My bankruptcy experts stand in the back of the room, but I don't think he's going to help me right now.
But it does point to another question. Judicial estoppel usually requires that the person who took the prior position have benefited from it.
Yes.
Had the position accepted and somehow that helped him. And I can imagine how undervaluing assets or not stating assets there might be an incentive for a petitioner in bankruptcy to do that. Do you know in this case did you posit a motive for the undervaluation?
Oh, absolutely, Your Honor. And this is addressed in the findings of fact by Judge CR2. And he found specifically there was something to gain in both the Chapter 7 and the Chapter 13. I mean, essentially, he took these items and, pursuant to a loan, moved them, did not disclose them, and he benefited by getting to keep those assets and get discharged in bankruptcy on the 7th.
So you're not asserting that he merely undervalued them, he did not bring them to the trustee's attention at all?
He did not. And in fact, the loan, the specific loan, the $40,000 loan for Mr. Perowitz that was the explanation for why he didn't put some of the items in there, that should have been disclosed. Because then the trustee would have had the ability under the circumstances to say, hey, look, by satisfying the loan, we could get all this property back to help satisfy the creditors. That could not be done. And Mr. Wortman, who was the attorney in bankruptcy court, testified in our case and said, gee, I asked the question such that should have been disclosed. It should have, and it was not to me. I can address the Chapter 13 if you'd like to also.
On the same point, yes.
Yes, and on the Chapter 13 later.
I mean, I can imagine how that would work, but I wasn't clear in this case what the motivation might have been.
And just for the court's reference, I believe it's addressed by Judge Harrod in his findings of facts at paragraph 30, where he specifically makes findings that says there was a benefit, because if in the 13, even though it was voluntarily dismissed, under the circumstances, there would have been the ability to convert it to a Chapter 7, liquidate those assets to satisfy the outstanding creditors instead of agreeing to any plan.
You know, I'm familiar with that, and I understand that, but I guess the problem I had with the 13 benefit, or that Judge Harrod found, was that if the debtor dismissed the 13, then the hypothetical possibility it could be converted into a Chapter 7 liquidation, well, the possibility it could have been converted into a Chapter 7 liquidation seems rather hypothetical to me. I mean, it didn't happen because it was dismissed. So I'm having a hard time seeing the benefits on the 13. I definitely see the argument on the 7, though.
And I guess all I could say with that is because he didn't disclose the assets, we'll never know. So it's almost like saying, gee, if you don't tell us, then we can't hang you on the fact that you received a benefit. I really don't know how to address that, Judge. I'd like to reserve some time if I could. Any other questions? Thank you very much.
Thank you, Judge Thompson. Good morning, Judge Norris, Judge Portley. Randy Sassman, appearing on behalf of Mark Rezac, the plaintiff, appellee, and cross-appellant in this case. And as Mr. Miles indicated, although I'm not sure what it means, I've been recently authorized to be a special counsel, I believe is the term, for the bankruptcy trustee. The question for you to decide today
Tell
is...
your grandkids, they'll be impressed.
It's the only time I've ever been called special, Judge, so I appreciate that. The question for you this morning is whether an insurance company that has not only admittedly breached its contract with its insured, but also has admittedly acted in bad faith towards its insured. And I say admittedly because that's what a jury of our peers found a little over 2 years ago, I guess now. And those findings have not been challenged at all by Farmers in this case. Whether that insurance company that has done that can now come to you and plead equity. Don't make us pay because that would be inequitable, to the detriment not only of its insured, but also, in cases such as this, potentially to the detriment of creditors in the bankruptcy court. Now, my plan is to first address with you why judicial estoppel is not appropriate under the long-standing Arizona law that has 3 elements of judicial estoppel: the identity of parties, identity of issues, and then proof that there was a benefit as a result of the prior representation.
But to be fair here, Mecum clearly involved a situation in which we had non-mutual parties.
Yes.
And where our court, this court and the Supreme Court have said in passing that mutuality is required, the facts have been they are the same parties. And so it was great. You're telling me what I already know. But this case squarely presents, as far as I can tell, a situation in which we don't have the same parties. So the issue that was preserved in standage is front and center because all of the other statements were in cases involving mutual parties, weren't they?
Well, no, I don't believe so, Your Honor. As I read the cases, there are 4 reported opinions now, and then there's 1 memorandum decision that I cited in my supplemental citation. The Otis Elevator case back in 1968 before Mecum, that involved different parties, and the court said judicial estoppel does not apply because of the lack of identity of issues. So I believe
We have Otis, and that's even older than Mecum, which
That's
is
correct.
almost older than I am. So we at least have 2 cases that address the issue squarely that reached opposite results.
Yes, and then we go from 68 to 71 in the Mecum decision, in which the court looks at it, and for whatever reason, it's a governmental entity. It was central to the misrepresentation was central to the case. Whatever the reason, the court, without any real analysis, looked at other cases and said, other jurisdictions, and said, well, these jurisdictions don't require it. We're not going to require it in this case. 27 years later, in the Alfie Properties case, I think it is clearly a lack of identity of parties in that case. And in that case, the court said no judicial estoppel because there's no identity of parties. So now we have 2 Court of Appeals opinions versus 1. Later, even than that, Judge Portley in 2014 in the KCI restaurant case.
Doesn't count.
Okay. I'm in trouble then, because I was going to rely on him. I was going to rely on his opinion.
Justice Portley.
Yes, Justice Portley. We'll elevate him right quick, and then we can all go
Then
home.
he really counts, okay?
Then we'll all go home.
Hires a justice.
But Judge Portley in the KCI restaurant case, clearly it was an issue. The identity of parties was an issue in that case. Paragraph 11 of that decision, Judge Portley says, no judicial estoppel because there's no identity of parties. And the plethora of cases, even though it was probably dicta in those other cases because there was an identity of parties, it's not binding then, but certainly it's persuasive authority as to what the court is thinking. I mean, I think that you all are cognizant when you make a statement in a reported opinion that people are going to be relying on that, and you don't just make those without thinking about them. And then, again, because Farmers suggest that there is no adequate authority on the issue, I brought up the memorandum decision that Judge Portley authored just 2 months ago in the Nick Hardy case.
Down there, isn't he?
And Farmers, late yesterday I got a response from Farmers to my supplemental citation of authority, and he said, well, Judge Portley didn't hold that you couldn't apply judicial estoppel because of lack of identity of parties. He applied it. He said you can't do that because this person was only a witness. Well, I think that's a bit disingenuous when Judge Portley referred back specifically to paragraph 11 of his KCI restaurant opinion, which squarely is on the identity of parties issue.
Let me ask you a question about this. Let's assume for the moment, and I asked Mr. Miles this, that we really can address this issue, that we are not foreclosed by binding Supreme Court authority that's directly on point, and so the issue is front and center. There has been, in similar doctrines, an erosion and rejection of mutuality. And there is an emphasis, when you read the cases that Farmers has cited, a true emphasis of the importance of turning a square corner in the judicial system. And that's a very powerful argument. On the merits, why doesn't it make sense to dispense with mutuality?
Well, several reasons.
Yeah.
I think, first of all, Your Honor, I think what our courts have recognized, I mean, every court that talks about this judicial estoppel warns about its use because, you know, it's a terribly powerful thing.
I couldn't agree more. And this seems facially seems like an appropriate case for its use.
Okay. And so we have to use it very cautiously and very judiciously. And, you know, my theory is that our court has kept it narrow because it understands the power that this can wield and how we essentially throw rules of law out the window when we kind of throw in, you know, fairness, and we don't think that was fair in this case. So it has to be construed very narrowly. I think that's why the authorities that limit it to the three elements do so. Even if you go beyond that, if you consider that, this still isn't a judicial estoppel case for several reasons. Because when you look at those opinions, in order to add those protections, they add some other requirements that we don't have, that the first representation was made fraudulently or within, you know, as part of a scheme as opposed to a mistake. Under our statement, you know, it could be a mistake. The prior representation could be a mistake.
If the court had not, forgive me, I may be wrong on the sequence of how this played out, but if the court had not rejected judicial estoppel as a issue of law, then if there was in fact a debatable issue, whether it was a legitimate mistake in completing the schedules versus intentional misconduct, that could have been sorted out by the finder of fact. But Farmers didn't get a chance to even get to that point.
Well, the finder of fact, I submit to you in this case, the jury found that there was no misrepresentation at any point in time.
But they were not instructed on whether there was a mistake for purposes of estoppel. That was not an issue that was presented to them. That's not part of the instructions.
Well, if you look at that instruction that the court gave, and it rejected my instruction, which basically said, in order for the misrepresentation defense to apply under the policy, it has to be a misrepresentation made to farmers. And the judge instead gave the instruction from the policy, which was broad enough to argue. And if you look at the closing argument, I submit that there are at least...
Forgive me. I think that my question is a little bit different. You posited that, well, judicial estoppel wouldn't apply here because, well, your client's completion of the schedules was obviously just by mistake. Well, Farmers presented pretty strong evidence that this was no mistake. But even if there is a debate over that, that's a fact issue as to whether it was a mistake or intentional fraud. They didn't get a chance to have that determined by a finder of fact on that narrow issue.
Well,
so, I mean, I feel a little bit that we're bootstrapping a little bit because the issue is judicial estoppel, and whether there was a mistake or whether it was intentional is yet to be decided squarely, at least based on what you just argued.
Yeah. I can, I mean, this wasn't really raised by Farmers, but I can tell you that when you look at the closing argument and the jury instruction, they argued that Mr. Rezac misrepresented to the bankruptcy court, and that was a misrepresentation to Farmers. And the jury instruction that was given was broad enough. I think I've got some notes as to what pages my opponent here argued that. But no less than 5 times he said, a misrepresentation to the bankruptcy court is a misrepresentation to Farmers, and the jury rejected any misrepresentation. So that's one reason in connection with this case. But if you're going to look at all of these cases, then let's look at what they say. And they talk about this as a doctrine that should be used sparingly to protect the interests of the judicial system. And so they require that fraud, and there was no evidence of fraud in this case. It was never argued in this case. Farmers never raised that issue in this case. The Ussery opinion that I cited in my supplemental citation, you know, it's kind of a summary of all of these other jurisdictions and how they look at this a little more broadly. But that court looked at the facts which you ought to do in every circumstance, and that case is amazingly similar here. I think the adjusters in that case for Allstate must have gone to the same seminar that the farmer adjusters did on how we're going to try to manipulate a claim that we otherwise recognize we need to pay. We're going to try to manipulate it so we don't pay a thing by way of judicial estoppel. In that case, the bankruptcy was filed in February of 2011, listed $2,700. And I'm going through this because I think the analysis is what's important. You know, each case has to be looked at on its own, and I think that you can decide, based on the record in this case, that judicial estoppel isn't an appropriate doctrine to apply in this case, regardless of whether identity of parties is required. So bankruptcy in 2011 listed $2,700 in personal property. A fire 8 months later, in November of 2011, a total loss, the dwelling and the personal property. They had personal property coverage of $206,000. Dwelling, I think, was $270,000 or a little more than that, and they submitted a proof of loss for the entire amount. To borrow a phrase from you, Judge Norris, Allstate said, "Gotcha! You said something different now than you said in your bankruptcy filing, so we've got you." And just like in this case, though, they didn't tell the insureds that. They denied the claim, saying, "Oh, you misrepresented in connection with your claim, and there's a provision in our policy that we can't prove. We understand that, but we're going to use that as the basis for denying your claim anyway. And then when you have to file suit against us, got you again. We're going to come in and say, judicial estoppel, it's not fair to make us pay money, even though we've collected those premiums over the years, even though we can't prove that he didn't own that property as of the date of loss," the important question in our case. And,
but as I recall, in that case, the bankruptcy was still open. I think Mr. Miles pointed this out.
Correct.
And the debtor filed amended schedules listing the property. So the court that was truly, or in the court that could have been misled through those corrective actions, there was no more basis for judicial estoppel because the matter had been corrected.
That's correct.
And that didn't happen. Well, at least that did not happen in this case, at least through, I believe, the trial.
That is correct.
Okay.
That is correct. And certainly it's not going to happen in this case because the bankruptcy trustee is involved. The issue is going to be resolved. The issue of entitlement to proceeds is going to be resolved in the place where it ought to be resolved, the bankruptcy court. And it's either going to be done, you know, the trustee is going to look at the facts and say, can I prove that he should have reported those collateral items as they've been referred to? Did he have a legal or equitable interest in them as of 2 years prior to the time he filed his bankruptcy pleading in, I think it was...
Hasn't the harm to the integrity of the judicial system already happened?
I don't believe so. I don't believe so, Your Honor.
Didn't that happen when Mr. Rezick received the discharge, at least in the Chapter 7?
Well, the case has been reopened.
Yes,
that's
I know,
the point.
after the fact, but he had the benefit of that discharge from shortly after 2007. That's a big benefit,
And,
that fresh
well,
start.
It may be taken away from him. That's the point. But that's going to be resolved in the bankruptcy court. The bankruptcy court has plenty of options to protect itself, and it doesn't need, you know, other courts looking out for it other than, you know, Farmer says, well, we couldn't tell the bankruptcy court about this. Look, they needed to provide some evidence, I believe, that he got a discharge because these items were not disclosed. We don't know what the bankruptcy trustee would have done. If you're defending that case, don't you go talk to the trustee and say, hey, I might need to use you as a witness in my case. If you had known this, what would you have done? That's how you get evidence to prove that that Mr. Rezac obtained a benefit, and that simply wasn't done in this case. And the trustee at that point in time can do whatever the trustees do. He can reopen the case or do whatever is necessary. But that was never done in this case. I pointed out, another way to do it is farmers can look at it and say, hey, under the policy that we issued, we owe this money. We don't know if it's to Mr. Rezac or the bankruptcy court, so we're going to interplead it. And I know they said, well, there's no, it's when there's two claimants. Well, I think that you certainly could have interpleaded the money in this particular case. But the Ussery case is a very enlightened analysis, and not just you said something here, you said something different here, we're going to give the insurance company the windfall, because that's exactly what happens in this case. The court in that case needed to look directly at the issue, and it pointed out that judicial estoppel is intended to be a flexible rule in which courts must take into account all of the circumstances. This bankruptcy is reopened now. It must be used with care, because the strident and mechanical application of judicial estoppel leads it to become a sword of the defense bar rather than a shield of judicial integrity. Insurance companies love this stuff. We owe this money, we would owe this money, but for the fact that we got you. The court in that
Farmers had not uncovered this. I don't see anything about your client coming forward and said, oh, I made a mistake in my petition or my schedules, and I shouldn't have gotten this discharge, or maybe there should have been additional sums for the creditors. I mean, they're the ones who uncovered all this. They're not, forgive me,
well,
I don't view them as the heavy here.
Yeah. Well, keep in mind that there's a question as to what needed to be disclosed in this case. And that's why I say that that's best suited for the bankruptcy court, because, frankly, I don't know a legal interest from an equitable interest. I stay as far away from bankruptcy court as I can. And I don't know anything about the valuations. I mean, I've learned more about bankruptcy in the past, well, it's been a while now since I had this case, I guess, and I still know very little. But, it's these companies that, and it was done in this case. Farmers says, oh, $160,000 versus $4,500. They know that's not the appropriate measure. They know that this is replacement cost, this is fair market value, but they don't even do any investigation to see if there really is a meaningful difference. Do we know what the bankruptcy trustee would have done? Do we know if there was any benefit to Mr. Rezac? And again, keep in mind that all of these courts that talk about judicial estoppel as being designed to protect the integrity of the courts, none of them talk about it's designed to punish, in this case, the bankrupt person. Because the bankruptcy court has plenty of punishing power, should I say. I looked that up specifically, and I think it's 5 years in prison and, as I recall, a huge fine. I don't remember what I put in the briefing, but there are plenty of powers by the bankruptcy court to deal with people who don't disclose property that should be disclosed.
Thank you, counsel.
Thank you.
I'd just like to address that last point. Mr. Sassman has stood up here and argued the facts to you, that we should have done further investigation, we should have talked to the trustee, we should have done all this. All that would be completely irrelevant, because I have no right to do that. Farmers has no right to do that, because without similarity of parties, that is not an available option or affirmative defense, which it was not in this case. And his got you and the rest of it is exactly what was argued to this jury that wound up being a $100,000 bad faith award. Now, who gets that money? Who gets the $170,000 property money? Where's that going? We don't know. No one knows. And the fact is, as I said before, this never would have been uncovered but for the investigation that was done by farmers. We wouldn't be standing here. The money would be his. He would have been paid the $160,000 by farmers because we have no right, unless there's identity of parties, to rely on this defense. So we wouldn't investigate it at all. The fact is, the findings of fact by Judge Herod teed this up. He found, and it's not been objected to, and it's not on appeal up to you because it was not the basis for a cross appeal. The findings of fact are the findings of fact, and the judge went out of his way to satisfy every single requirement in those paragraphs, that they profited, they were relieved of debt, that the valuation, Mr. Sassman just argued valuation is the issue and it could be a mistake. That was not found by Judge Herod. He looked at, and that was presented, that my attorney told me it was garage sale prices. The judge specifically considered that in his order and said the discrepancy between, even if he believed that and it happened, doesn't justify or excuse the nondisclosure. That all these questions that were raised and argued by Mr. Sassman were addressed by Judge Herod. And if you read that order, the only thing that he teed up for this case, the only issue, and he would have found, as you look and read through it, if there was identity of parties or that's not a requirement, this case is over. Our summary judgment would have been granted. We would have never sat through any trial, and that would be the end of the case. So we ask you to please, in accordance with the Meekum case, find that that is not a requirement in the interest of what's best for the court system, not the litigants. Thank you.
Thank you, counsel. We'll take the matter under advisement. We'll issue our decision in due course. Court's adjourned.